All right, welcome back to the deep dive. So today we're cracking open a file that is it's right at that intersection of law, history, and let's be real, pure political adrenaline.
It really is. We're talking about the Supreme Court.
Exactly. The Marble Temple, the highest court in the land. And, for something that's supposed to be so quiet and deliberative, it makes a ton of noise.
Well, that noise really brings us to what our source material calls the Big Q.
The big Q. Is the Supreme Court a neutral arbiter of the law? Just calling balls and strikes? Or is it, deep down, a political player?
It's the central question, really, because on paper you have this image of robes and objectivity, but in practice, every single vacancy now feels like this massive political earthquake.
Right. If it's just about reading the law, why does the entire country seem to grind to a halt when one of those 9 seats opens up?
That's what we need to figure out. And I think our stack today is really good for this. We've got some lecture slides on constitutional theory, textbook excerpts on how justices get picked, and a snapshot of who's on the court as of early 2024.
So our mission, really, is to decode the whole structure. How do 9 people get that much power? And is that power as neutral as we're told it's supposed to be?
And to do that, you have to start at the beginning. I mean, the very beginning. The Constitution itself. Article 3.
I was surprised looking at this. Article 3 is so short compared to the parts about Congress or the president.
It is incredibly sparse. Section 1 just says the judicial power is vested in one Supreme Court. That's it. One. It leaves the creation of all the lower courts, the inferior courts, completely up to Congress.
But the phrase that really defines everything, the one that causes all the controversy we're talking about, is about the term limit, or I guess the lack of one. It says they hold their offices during good behavior.
Good behavior. It's such a great 18th century phrase, isn't it?
It sounds like something you'd say to a toddler.
Exactly. But in this context, it means one thing. Life tenure. Once you are confirmed, that seat is yours until you die, you resign, or you decide to retire.
Unless you get impeached.
Theoretically, yes. But the sources point out that's basically a non-starter. It almost never happens. So for all practical purposes, they're untouchable.
So why? Why set up a system where 9 people have a job for life with, no accountability to voters?
It all comes down to insulation. The founders were genuinely scared of a court that would bend to the will of the mob or to a powerful president. The idea was if a judge doesn't have to worry about re-election or campaign donors, they're free to just follow the law.
In theory.
In theory. But the data in our slides shows how that's evolved. Here's a stat that it blew my mind. Since 1955, only 3 justices have actually died in office.
Only 3? That's a huge shift.
It is. It used to be they served until they dropped. But now, with modern medicine and, frankly, modern politics, the game has changed.
So if they aren't dying, they're retiring. And our source calls this strategic retirement.
And this is where that political player argument really starts to get some teeth. A strategic retirement is when a justice looks at the calendar, looks at who's in the White House, and makes a calculation.
They wait. They wait for a president from their own party, or at least one who shares their ideology.
Exactly. A conservative justice will hang on for dear life if a Democrat is president, and vice versa. It turns the very act of leaving into a political weapon. You're trying to pass the baton to your teammate.
Which, right out of the gate, that kind of complicates the whole neutral arbiter idea.
That certainly does. If, when you leave, your job is determined by who won the last election, that's a political act.
So before we get to who these people are, let's just quickly cover what they do, their jurisdiction.
Right. Their scope is huge. They hear cases that come up under the Constitution, federal laws, treaties. They also handle disputes between states like, Florida and Georgia fighting over water rights.
But they're not a trial court, right? No juries or witnesses.
Correct. That's a big misconception. They're almost entirely an appellate court. Cases start in a district court, maybe go to a circuit court of appeals, and the Supreme Court is the final stop, the end of the line.
The court of last resort.
Precisely. Once they rule, that's it. There is nowhere else to appeal. Their word is final unless you actually amend the Constitution.
There's one thing they can't touch, though. The slides mention it.
Impeachment. That belongs solely to the Senate. The court stays completely out of it.
Okay, so we've got the blueprint. Life tenure, final say, strategic exits. Now let's talk about the actual people in the robes. We have a list from January 2024.
This is where theory meets reality.
First, the number. 9 justices. But I learned from our notes that the Constitution never actually says it has to be 9.
No, it doesn't. That number is just set by a law from Congress. We've had as few as 6, as many as 10. It's been 9 since 1869, but Congress could, in theory, change it tomorrow.
And we call the current court the Roberts Court.
Yeah. Courts are always named after the Chief Justice, who kind of sets the tone. Right now, that's John Roberts, appointed by George W. Bush way back in 2005.
This roll call is fascinating. It's like looking at the rings of a tree. You can see the political history layered in.
That's a perfect way to put it. You've got different presidential eras all sitting on one bench.
So the most senior justice right now is Clarence Thomas.
Appointed in 1991 by George H.W. Bush. Think about that. He's been on the court for over 3 decades.
Then you've got the George W. Bush layer. So that's Roberts and Samuel Alito.
Right.
Then the Obama years bring us Sonia Sotomayor and Elena Kagan.
And then the Trump years. This part of the source material really jumps out. In one 4-year term, Donald Trump got 3 appointments.
3. Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett.
It's a huge historical anomaly. I mean, Jimmy Carter got 0 in 4 years.
Yeah.
To get 3 is just, it's a political lottery win that reshaped the court for a generation.
And most recently, President Biden appointed Ketanji Brown Jackson.
So when you look at that list, you see the stamp of 5 different presidents. And this leads to what the source calls the echo chamber effect.
Oh, the Nixon example for this was perfect.
It's the best illustration. Richard Nixon resigned in 1974. He died in 1994. But his appointee, William Rehnquist, was Chief Justice until 2005.
That's just wild. Nixon had been dead for over a decade, but his guy was still running the court.
That's the point. A president's influence echoes for decades, which is why that big Q, is it political, is so hard to answer. Of course the choice is political, and that choice becomes a time capsule.
Okay, so we know who they are, but the real debate, the real friction comes from how they think. This is where we get into judicial philosophy.
Right. And we tend to simplify it to liberal versus conservative, but the sources push us to use the legal terms, strict constructionists and loose constructionists.
Let's start with strict constructionists. They're also called originalists.
Yes. The core belief is that you interpret the Constitution exactly as it was written. You ask, what did these words mean to the people who wrote them in 1787? The meaning is fixed. It's frozen in time.
And the source has that killer quote from the late Justice Antonin Scalia. He said, "The Constitution that I interpret and apply is not living but dead."
Our first responsibility is not to make sense of the law. Our first responsibility is to follow the text of the law. It's a blunt way of putting it. But his point was, it's not a judge's job to update the Constitution. If society wants to change the law, that's what Congress is for.
And this view usually favors states' rights.
Generally, yeah. Because the original document gave the federal government very few, very specific powers. So a strict constructionist often says, if it's not written down in here, the federal government can't do it. It's up to the states.
Okay, so on the flip side, you have the loose constructionists, the living Constitution people.
Their view is that the Constitution is a framework of broad principles: liberty, equality, due process. And the application of those principles has to evolve as society evolves.
Because the framers couldn't have imagined, I don't know, the internet or wiretapping.
Exactly. A loose constructionist would argue that if you only applied the 18th century meaning, the document becomes obsolete. So they're more willing to find implied rights and powers to deal with modern problems. This usually leads to a stronger federal government.
So, okay, let's make this real. Why does any of this matter to someone listening right now?
Well, the source gives a great, if contentious example: abortion.
Okay.
Think about it. The word abortion appears nowhere in the Constitution. It's just not there.
So a strict constructionist says,
read the text. It's not in there. Therefore, there's no federal constitutional right to it. It's a question for state legislatures to decide.
And a loose constructionist.
They might look at the 14th Amendment's guarantee of liberty and ask, okay, in the 21st century, does the principle of liberty include a right to privacy and bodily autonomy? They would say yes, and therefore the right is protected, even if it's not explicitly written.
Wow. So it's the same document, the same words, but you get 2 completely opposite conclusions.
And that is the absolute key to this whole debate. The law isn't a math problem. It's interpreted by humans with different philosophies, which explains why the appointment process is such a war.
It totally does. You're not just picking a smart lawyer. You're picking a philosophy that you know will lead to the outcomes you want for the next 30 years.
Precisely.
Yeah.
And the sources break down that process. It's a real gauntlet.
It all starts with a vacancy, which happens on average every 2 years, but as we saw, that can be super random.
Total luck at the draw.
When a spot opens up, the president starts a search. But where are they even looking? What's the recruitment pool?
Well, today, the farm team is almost entirely the federal courts of appeals. That's the level right below the Supreme Court.
Gorsuch, Kavanaugh, Barrett, they all came from there.
Right. And it's seen as the safest bet.
Why safest?
Because they have a long paper trail. You can go back and read hundreds of their previous rulings. A president can see exactly how they think and vote. It minimizes the risk of being surprised later.
It used to be different, though. The source says politicians were more common. Earl Warren was a governor.
Can you imagine that today? It's just too risky for a president. A politician is a wild card. They don't have that long judicial record. Presidents want a sure thing.
Speaking of sure things, let's talk about the political math. Ideology is number one. But the sources say age is the real strategic weapon.
Age is the legacy multiplier. Because of life tenure, you want them as young as possible.
Yeah. The source contrasts Trump picking Amy Coney Barrett at 48 with Biden picking Ketanji Brown Jackson at 53. Barrett could be writing opinions into the 2060s.
It's the most permanent thing a president does. Laws get repealed, executive orders get reversed. But a 48-year-old justice is a 40-year legacy.
The sources also mention the ABA ratings from the American Bar Association.
Yeah, they give a rating. Well qualified, qualified, or not qualified. It's not official, but a bad rating can be used as ammunition during the confirmation hearings in the Senate.
Which is the final boss battle. The president nominates, the Senate Judiciary Committee holds hearings, and then the full Senate votes.
And that vote now only needs a simple majority. The rules changed. So if your party controls the Senate, even by one vote, you can push a nominee through.
Okay. So we've looked at the structure, the people, the philosophies, and the brutal politics of getting on the court. Let's circle back. The big Q. Is the Supreme Court political?
Well, let's lay out the yes case from our sources.
The appointment process is 100% political. A political president picks someone to please their political base.
Check. And we have justices timing their retirements for political reasons.
And we all talk about them in political terms. The liberal wing and the conservative wing, we color code their votes.
It's hard to call it neutral when we can predict their votes with pretty high accuracy just based on which president appointed them.
But there's a no case, too, or at least an argument for neutrality.
And it all comes back to good behavior, that life tenure. Once they're on that bench, the political leash is, in theory, cut.
They don't have to raise money. They don't have to worry about polls.
Right. A politician's question is, will this help me get reelected? A justice's question is this consistent with the law? Those are very different incentives.
And our source makes a key point. Justices sometimes surprise the presidents who appointed them.
That's the ultimate proof of independence, isn't it? There's a long history of presidents getting frustrated because their guy on the court starts voting in ways they didn't expect.
I think Eisenhower famously said appointing Earl Warren was the biggest damn fool mistake I ever made.
Exactly. He thought he was picking a moderate conservative, and Warren ended up leading one of the most liberal courts in history. That can only happen because of that insulation from politics.
So it really is a hybrid. It's born out of a purely political process, but designed to operate above it.
That's the paradox. It's a legal institution staffed through a political process.
This has been a really fascinating look behind the curtain.
It really demystifies it. It's not magic. It's people. Chosen by people, interpreting words written by people.
So before we sign off, we have to leave you with one final thought to chew on. It's from the plenary section of our sources, and it's a bit of a mind bender.
It's the big one.
Okay, so we've established that the court basically makes law with its rulings, and that a strict judge and a loose judge can look at the same exact words and reach opposite conclusions. So here's the question. If the meaning of the Constitution depends entirely on the philosophy of the 9 people sitting in those chairs, does the Constitution itself actually change every time a new justice is appointed?
That's it. Does the supreme law of the land actually mean something different on a Tuesday than it did on a Monday just because someone retired and someone else got the job?
It suggests the law isn't this solid, unchanging rock. Maybe it's more like a liquid that just takes the shape of whatever container it's poured into.
Something to think about the next time you see that breaking news banner flash across your screen.
Thanks for diving in with us. We'll see you in the next one.
See you next time.